House of Representatives and for us to find something that can be passed in order to get us to conference committee.
We will have to leave it there. Congressman Hakeem Jeffries, thank you for talking to our viewers.
Thank you very much.
And the House is in early this morning for their legislative session. Live coverage now here on C-SPAN.
The Speaker's Rooms, Washington, D.C., December 5th, 2013. I hereby appoint the Honorable Virginia Fox to act as Speaker Pro Tempore on this day. Signed, John A. Boehner, Speaker of the House of Representatives.
The prayer will be offered by our chaplain, Father Conroy.
Let us pray. Eternal God, we give you thanks for giving us another day. We pause in your presence and ask guidance for the men and women of the People's House. Enable them, O God, to act on what they believe to be right and true and just, and to do so in ways that show respect for those with whom they disagree. Send your spirit of peace upon our nation. Endow the members of this House and all our governmental leaders with the wisdom to respond with whatever policies and laws might be needed to ensure greater peace and security in our land. Bless us this day and every day, and may all that is done be for your greater honor and glory. Amen.
Amen. The Chair has examined the journal of the last day's proceeding and announces to the House her approval thereof. Pursuant to Clause 1 of Rule 1, the journal stands approved. For what purpose does the gentleman from Montana seek recognition?
Madam Speaker, pursuant to Clause 1, Rule 1, I demand a vote on agreeing to the Speaker's approval of the journal.
The question is on agreeing to the Speaker's approval of the journal. Those in favor, please say aye. Aye. Those opposed, please say no. The ayes have it. The journal stands approved. For what purpose does the gentleman from Montana seek recognition?
Madam Speaker, I object to the vote on the grounds that a quorum is not present and make the point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20, further proceedings on this question are postponed. The Pledge of Allegiance will be led by the gentlewoman from Ohio, Ms. Fudge.
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Chair will entertain up to 5 requests for 1-minute speeches on each side of the aisle. For what purpose does the gentleman from Arkansas seek recognition?
Yes, unanimous consent to address the House for 1 minute.
Without objection, the gentleman is recognized for 1 minute.
Thank you, Madam Speaker. Today I rise to honor the 50th anniversary of my good friends and fellow Arkansans, Benny and Nelda Speaks. Benny and Nelda first met in Mountain Home, Arkansas. Benny fresh out of the Navy, Nelda having returned home from business college in Springfield, Missouri. They were married on December 6, 1963. They have 1 daughter, LaDonia Speaks Morantz, 2 grandchildren, Natasha and Brandon, and were blessed with 1 great-grandson, Logan. Madam Speaker, it's no easy task making it to the 50-year anniversary. It takes great commitment, a willingness to compromise and to listen, and a loving spirit. These qualities embody the relationship of the Speaks, whose marriage serves as a testament and example to the rest of us. The Speaks are involved community leaders who truly care about Arkansas and have devoted much of their time and effort giving back to their community. I thank the Speaks for their friendship over the years, and I'm so glad to be able to wish them a happy 50th wedding anniversary this December 6th. Yield back.
The gentleman yields back. For what purpose does the gentlewoman from California seek recognition? Without objection, the gentlewoman is recognized for 1 minute.
Thank you, Madam Speaker. The Affordable Care Act is already improving access to quality, affordable health care for millions, including my constituents. In my home state, for example, Covered California is a shining example of how the Affordable Care Act, when implemented fully, will be a success. California's exchange is now enrolling thousands of Californians into health care coverage every day. Residents of my district, ranging from young adults to seniors to children with pre-existing conditions and those who cannot afford health insurance, have been receiving critical protections in savings because of the Affordable Care Act. In fact, one constituent wrote me recently after receiving a letter from his insurance company. After looking at the plans offered through Covered California, he was able to find coverage that was both more affordable and better for him. And he told me that he does not want to put insurance companies back in charge and pay higher premiums for less coverage. Yet every time Republicans vote to repeal or dismantle the Affordable Care Act, they make it perfectly clear that charging women more for being a woman is okay, that denying victims of domestic violence coverage is okay, and allowing insurance companies to increase premiums to increase profits is okay.
The gentlewoman's time has expired. For what purpose does the gentleman from Montana seek recognition?
Yes, consent to address the House for 1 minute if I can extend my remarks.
Without objection, the gentleman is recognized for 1 minute.
Madam Speaker, this weekend, the Bozeman High School girls cross-country team will be in Portland, Oregon to run in the Nike Cross National Championship. These dedicated and talented young women have won 7 consecutive Montana Class AA state championships and have competed for 5 consecutive years at the Nike Cross Northwest Regionals. This year, after securing their 7th state championship, they came in first at the Nike Cross Northwest Regionals in Boise, Idaho. They will now advance and compete this Saturday against high school runners from across the country at the Nike Cross Nationals. As a graduate of Bozeman High School and a Bozeman Hawk, I couldn't be more proud to see the Bozeman girls cross-country team representing Montana at the Nike Cross Nationals. I join all Montanans in wishing them the very best on Saturday. Go Hawks!
For what purpose does the gentlewoman from Ohio seek recognition? Without objection, the gentlewoman is recognized for 1 minute.
Thank you. Madam Speaker, prior to the passage of the Affordable Care Act, 23% of Ohioans with incomes below 133% of the federal poverty level were uninsured. But thanks to the expansion of Medicaid in my home state of Ohio, all of the almost 600,000 residents who are uninsured with incomes below 138% of the federal poverty level will now have access to Medicaid coverage. In my district alone, an additional 72,000 people became eligible for Medicaid. And next Monday, December 9th, all of these individuals will be able to begin signing up for health care coverage that begins January 1st. No longer will I receive calls from constituents like Brandon Proctor, who told me that he was too rich for Medicaid but too poor for subsidies. This is the way the Affordable Care Act is designed to work. Finally, all Ohioans will have access to quality and affordable health care. I yield back.
The gentlewoman yields back. For what purpose does the gentleman from Georgia seek recognition?
I ask unanimous consent to address the House for 1 minute and revise and extend my remarks.
Without objection, the gentleman is recognized for 1 minute.
Thank you, ma'am. Madam Speaker, I rise today to pay tribute to an incredible man of faith with a true calling and a heart for serving the Lord, Bishop Wellington Boone. Bishop Wellington Boone was ordained into ministry in 1973. And in that same year, he married his childhood sweetheart, Catherine. Today, Bishop Boone not only celebrates 40 years of ministry, but 40 years of a loving marriage with his wife. In today's world, it is unique and certainly admirable to see a couple celebrate 40 years of marriage. Their long-lasting marriage is a testament to not only their commitment to each other, but their dedication to serving the Lord. Bishop Boone's 40 years of leadership and service in ministry is also a tremendous accomplishment, and one that deserves recognition. Through his work, Bishop Boone has faithfully led others in their quest to glorify and serve the Lord. Mr. Speaker, or Madam Speaker, I ask you to join me in congratulating Bishop Boone as he celebrates 40 years of ministry and 40 years of marriage with his lovely wife, Catherine. I yield back.
The gentleman yields back. For what purpose does the gentleman from California seek recognition?
Madam Speaker, I ask unanimous consent to address the House for 1 minute and to revise and extend my remarks.
Without objection, the gentleman is recognized for 1 minute.
I rise as a member of the Safe Climate Caucus to call attention to a new report from the nation's premier scientific body, the National Academy of Sciences. We typically associate climate change with gradual, longer-term problems. But according to the Academy, climate change could also pose a risk of rapid, hard-to-predict environmental changes that have the potential to cause widespread damage in the near term. The report warns that the collapse of the polar sea ice could send sea levels soaring. The destruction of the coral reefs could cause a mass extinction of sea life. The elimination of summer sea ice in the Arctic could alter the world's weather patterns. These tipping points could happen suddenly. It's reckless to do nothing in face of these threats. If there is a 10% chance that these threats would happen, it's irresponsible for us to ignore it. Dr. Richard Alley, one of the authors, said, "You can't see it coming. You can't prepare for it. Congress is irresponsible if we don't take this issue seriously to pass on our planet worthy for our children and our grandchildren's future."
The gentleman's time has expired. For what purpose does the gentleman from Missouri seek recognition?
To address the House.
Without objection, the gentleman is recognized for 1 minute.
Thank you, Madam Speaker. Madam Speaker, next week the National Park Service will begin holding public meetings on its ridiculous plan to limit recreational activity on the Ozark National Scenic Riverways in Missouri's 8th District. I urge families and individuals across Missouri to attend these hearings and oppose the Obama administration's changes to our riverways. Let me reiterate that I have said to the Secretary of Interior, Sally Jewell, and the Director of the National Park Service, Jonathan Jarvis, that we adamantly oppose the proposal to appease environmentalists by limiting the public use and enjoyment of our riverways. This proposal that would hurt small businesses that rely on the riverways and keep my constituents from enjoying the riverways that belong to them. Mr. Speaker, I urge my constituents to attend public meetings in Van Buren, Salem, and even Kirkwood to show opposition to the Obama administration's Park Service attempts to restrict our access to our rivers.
The gentleman's time has expired. For what purpose does the gentleman from Texas seek recognition? Without objection, the gentleman from Texas is recognized.
Thank you, Madam Speaker. Madam Speaker, I want to thank Congressman Christopher Smith for leading a CODEL to the Philippines. I, along with Congressman Trent Franks, were members of the CODEL. And I want people to know that there is still great work to be done for our friends in the Philippines. This picture depicts some of the damages that we were able to see while we were there in Tacloban, which is a province of the Philippines. This is another picture that shows actual homes. This is a USAID sign, and these are places where people are actually dwelling at this time. The number one problem that they have right now is shelter. I would also add that our military has done an outstanding job. I had an opportunity to meet with many of our military people who were there with heavy equipment, and I commend them for what they have done. Finally, I'd like to say this. We have H.R. 3602, which would accord people from the Philippines in the United States temporary protected status. This would allow them to stay here as opposed to go home where the income is less than $2 a day for more than 40% of the people. My hope is that we can pass H.R. 3602. It does not give any pathway to citizenship. It will only allow them to send money back home while they're here working in the United States. Thank you, Madam Speaker. I yield back.
The gentleman's time has expired. For what purpose does the gentleman from Illinois seek recognition?
For 1 minute, revise and extend my remarks.
Without objection, the gentleman from Illinois is recognized for 1 minute.
Thank you, Madam Speaker. I rise to congratulate the Batavia High School Bulldogs for winning their first ever Illinois State Football Championship. On Saturday, November 30th, Batavia faced off against Richards High School, which shares the same nickname, in an epic battle of the Bulldogs. At NIU's Husky Stadium in DeKalb, an estimated 12,000 Batavia fans roared as Micah Coffey, the quarterback, threw for 2 touchdowns, and running back Anthony Scacia ran for 3 more. Both teams fought hard, but Batavia prevailed, capping their virtually undefeated season with a 34-14 victory. I commend Coach Dennis Piron and the entire Bulldogs team for the hard work that went into a strong 13-1 season and the IHSA Class 6A state championship. Go Bulldogs. I yield back.
The gentleman yields back. For what purpose does the gentleman from Virginia seek recognition?
Madam Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 3309, which will soon be under consideration.
Without objection. Pursuant to House Resolution 429 and Rule 18, the Chair declares the House in the Committee of the Whole House on the State of the Union for the consideration of H.R. 3309. The Chair appoints the gentlewoman from North Carolina, Ms. Fox, to preside over the Committee of the Whole.
The House is in the Committee of the Whole House on the State of the Union for the consideration of H.R. 3309, which the clerk will report by title.
A bill to amend Title 35 United States Code and the Leahy-Smith America Invents Act to make improvements and technical corrections and for other purposes.
Pursuant to the rule, the bill is considered read the first time. The gentleman from Virginia, Mr. Goodlatte, and the gentleman from Michigan, Mr. Conyers, each will control 30 minutes. The Chair recognizes the gentleman from Virginia.
Madam Chairman, I yield myself such time as I may consume.
The gentleman is recognized.
Today we are here to consider H.R. 3309, the Innovation Act. The enactment of this bill is something I consider central to U.S. competitiveness, job creation, and our nation's future economic security. This bill takes meaningful steps to address the abusive practices that have damaged our patent system and resulted in significant economic harm to our nation. During the last Congress, we passed the America Invents Act. Many view the AIA as the most comprehensive overhaul of our patent system since the 1836 Patent Act. However, the AIA was in many respects a prospective bill. The problems that the Innovation Act will solve are more immediate and go to the heart of current abusive patent litigation practices. This bill builds on our efforts over the past decade. It can be said that this bill is the product of years of work. We have worked with members of both parties in both the Senate and the House, with stakeholders from all areas of our economy, and with the administration and the courts. To ensure an open, deliberative, and thoughtful process, we held several hearings and issued 2 public discussion drafts in May and September of this year, which led to the formal introduction of the Innovation Act in October. I strongly believe that the Innovation Act takes the necessary steps to address abusive patent litigation. Abusive patent litigation is a drag on our economy. Everyone from independent inventors to startups to mid and large-sized businesses face this constant threat. The tens of billions of dollars spent on settlements and litigation expenses associated with abusive patent suits represent truly wasted capital that could have been used to create new jobs, fund R&D, and create new innovations and technologies that promote the progress of science and useful arts. And that's what innovation is really about, isn't it? If you're able to create something, invent something new and unique, then you should be allowed to sell your product, grow your business, hire more workers, and live the American dream. The Innovation Act puts forward reasonable policies that allow for more transparency and brings fundamental fairness to the patent system and the courts. The Innovation Act is designed to deal with systemic issues surrounding abusive patent litigation as a whole and includes a number of provisions designed to ameliorate this significant problem. Within the past couple of years, we have seen an exponential increase in the use of weak or poorly granted patents against American businesses with the hopes of securing a quick payday. Many of these abusive practices are focused not just on larger companies, but against small and medium-sized businesses as well. These suits target a settlement just under what it would cost for litigation, knowing that these businesses will want to avoid costly litigation and probably pay up. The patent system was never intended to be a playground for litigation, extortion, and frivolous claims. The Innovation Act contains needed reforms to address the issues that businesses of all sizes and industries face from patent troll-type behavior, while keeping in mind several key principles, including targeting abusive behavior rather than specific entities, preserving valid patent enforcement tools, preserving patent property rights, promoting invention by independents and small businesses, and strengthening the overall patent system. Congress, the federal courts, and the PTO must take the necessary steps to ensure that the patent system lives up to its constitutional underpinnings. And let me be clear about Congress's constitutional authority in this area. The Constitution grants Congress the power to create the federal courts, and the Supreme Court has long recognized that the prescription of court procedure falls within the legislative function. To that end, the Innovation Act includes heightened pleading standards and transparency provisions, requiring parties to do a bit of due diligence up front before filing an infringement suit is just plain common sense. It not only reduces litigation expenses, but saves the courts time and resources. Greater transparency and information makes our patent system stronger. The Innovation Act also provides for more clarity surrounding initial discovery, case management, fee shifting, joinder, the common law doctrine of customer stays, and protecting IP licenses in bankruptcy. Further, the bill's provisions are designed to work hand in hand with the procedures and practices of the Judicial Conference, including the Rules Enabling Act, and the courts, providing them with clear policy guidance while ensuring that we are not predetermining outcomes and that the final rules and the legislation's implementation in the courts will be both deliberative and effective. Today we are taking a pivotal step toward eliminating the abuses of our patent system, discouraging frivolous patent litigation, and keeping U.S. patent laws up to date. The Innovation Act will help fuel the engine of American innovation and creativity, help create new jobs, and grow our economy. And I reserve the balance of my time.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Madam Speaker, I yield my time, myself as much time as I may consume.
The gentleman from Michigan is recognized.
Of course, we're here to correct the problem of patent trolls. And we're unfortunately faced with a measure, H.R. 3309, that goes well beyond the issue of trolls and would unfortunately weaken every single patent in America. And I say this for several reasons. First, 3309 fails to respond to the single most important problem facing our patent system today, the continuing diversion of patent fees. Nearly $150 million in badly needed user fees have been diverted in fiscal 2013, and it's estimated that $1 billion in fees have been diverted in the last 2 decades. This cannot go on. Next, the bill's heightened pleading requirements will deny legitimate inventors access to the court in several critical respects. They will have an unfair impact against patent holders across the board. They are drafted in a one-sided manner that will prolong litigation. They're unnecessary because the courts are already addressing pleading standards. The next thing I would bring to your attention is the bill's fee-shifting requirements will favor wealthy parties and chill meritorious claims. I'm not surprised that the other side would be advancing something like this, but it's shocking because the provision is drafted in an overly broad manner and will apply well beyond patent infringement actions. The next thing that I would point out is that the bill's discovery limitations are counterproductive. Limiting discovery prior to holding hearings to construe patent claims and determine their scope will delay litigation and lead to even greater expenses for the parties. And finally, H.R. 3309 mandates that federal judiciary adopt a series of new rules and judicial changes that will make it more difficult for inventors to protect their patent rights. These changes are strongly opposed by the Judicial Conference of the United States, the principal policy-making body that Congress established to administer our federal court system. I spent my entire career on judiciary to help foster an independent judiciary that can resolve disputes between parties on a fair and dispassionate basis based on an even-handed set of rules. There's little doubt that the federal judiciary, as evidenced by its exceedingly deliberative rulemaking process, is in a far better position than the entire Congress to set the proper rules for their own courtroom on this matter. By unbalancing the patent system, we send a signal to inventors, the very people doing the research and developing the cures that benefit us all every day, that their inventions are not worthy of full legal protection. This means that the next cure for cancer or technological breakthrough may be stymied and perhaps never come, or be developed abroad rather than in the United States. We can and should respond to the problem of patent trolls in a direct but fair and targeted manner. But we must not do so in a way that punishes our innovators and inhibits innovation. And, Madam Speaker, I reserve the balance of my time.
The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Chairman, it's now my pleasure to yield 1 minute to the gentleman from North Carolina, Mr. Holding, a distinguished member of the Judiciary Committee.
The gentleman from North Carolina is recognized for 1 minute.
Madam Chairman, I rise in support of H.R. 3309, the Innovation Act, because it's crucial to preserving the integrity of our nation's innovators and creators. One of the constitutional responsibilities of Congress is to promote the progress of science and useful arts, and this legislation does just that by deterring abuse of our patent litigation system. As a United States Attorney, I saw how patent trolls abuse our patent litigation system by acquiring patents that they have no intention of using for anything other than their own monetary gain. Patent trolls are companies for sue companies for allegedly infringing on patents they had no business acquiring in the first place. The Innovation Act, which I am proud to co-sponsor, makes it more difficult for patent trolls to form a case. It also aligns fee shifting in patent cases, which discourages frivolous cases. Madam Chairman, there's a lot of opportunity for job creation in the technology sector. The Innovation Act is essential to protecting these technology companies from fraud and abuse, and I want to thank Chairman Goodlatte for his leadership on this issue, and I yield back.
The gentleman from North Carolina yields back. The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Madam Speaker, I yield to Mr. Massey of Kentucky 3 minutes.
The gentleman from Kentucky is recognized for 3 minutes.
Oh, come on, folks. Get me up to date. Don't let someone start begging me every time. Who's next?
Thank you, Mr. Speaker. I want to briefly tell you about a young boy who grew up in modest surroundings in rural Kentucky. Although he had no money, he was inspired to invent. So he collected junk to build his inventions. Broken clocks, radios, vacuum cleaners. Who knows, maybe one day he could assemble this junk into an invention that would allow him to pull himself out of his humdrum environment. He was inspired to invent by stories of Edison, Ford, Tesla. In the 7th grade, he invented this robot arm that you see here, which he won him a prize at the science fair. He even invented a flower pot for his grandmother that would water itself. He went on to college where he met other inventors, inspired again not just by their creativity, but by the fact that they can make an honest living by improving the lives of others. One of his inventor's friends invented a robot that vacuums floors for millions of people now. The boy went on This boy went on to invent a touch interface for computers, obtain 29 patents, raise venture capital, and create dozens of jobs. His story is only possible in America, where a robust intellectual property system and judicial system work together to protect the property rights of inventors. Knowing this and relying on this, many inventors dedicate their lives, their entire lives, to inventing things that will improve and extend the lives of others. Today's patent reform bill is a serious threat to American inventors. That's why inventors are urging us not to pass this bill today. It will extinguish creativity and invention in America. Recklessly weakening the patent system, as this bill does, will deprive inventors of income and a livelihood. They will pursue other careers. As the role models for young inventors quietly fade into history, fewer young students will pursue invention. A decade from now, Congress will further lament the lack of interest among the next generation in science, engineering, technology, and math, arrogantly unaware that it was Congress that killed that interest today with this bill should it pass. But how do I know this boy's story so well? How can I anticipate the unintended consequences of this bill? I'm the boy in this picture, and that was my story. It would be shameful and wrong to kick out the ladder from our next generation of inventors, as this bill would do. But if my story doesn't compel you, please listen to the words of Dean Kamen. Pick your favorite inventor in history, Tesla, Edison. Dean Kamen is that inventor of our time. Perhaps you know him as the inventor of the Segway, but he's invented a dialysis machine, an insulin pump, a self-balancing wheelchair. These inventions have improved the lives of millions of people all over the world. Here's what Mr. Kamen has to say about this very legislation. Quote, adding uncertainty and cost to getting and maintaining patents will be the largest single cause of the decline of innovation and therefore the economy in this country that I've seen in my lifetime, unquote. Mr. Kamen doesn't just invent, he inspires the next generation to invent with his America First robotics contest that millions of students have participated in.
A half minute additionally.
The gentleman's recognized for an additional 30 seconds.
He inspires the next generation to invent with this robotics contest. I'm scheduled to speak at 2 of those robotics contests in Kentucky this weekend, not to inspire these kids to be politicians, but to inspire them to be inventors. Should this bill pass? Should we kick the ladder out from our young inventors? It's going to be hard for me to face them Saturday. I urge my colleagues to listen to the inventors of America who are pleading them to oppose this bill. Thank you, and I yield back.
The gentleman yields back. The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Chairman, I am pleased to yield 1 minute to the gentleman from Texas, Mr. Farenthold, who is a distinguished member of the Judiciary Committee.
The gentleman from Texas is recognized for 1 minute.
Thank you very much. You know, the patent system is a vital part of our national identity. It stimulates American ingenuity and it enhances our global competitive stance. Traditionally, patent holders have asserted their patents against those who produce infringing technologies. But in recent years, abusive patent litigation, patent trolling, has ballooned as companies have emerged solely to buy questionable, vaguely defined patents and assert them against thousands of end users in hope of extracting licensing fees. Right now, the patent trolls are going after hotels or restaurants. It's the reason you don't have Wi-Fi in more restaurants. Well, guess what? This is legalized extortion, and H.R. 3309 will significantly curb this problem. Though I have some problems with Section 9C and the PTO's ability to apply the broadest reasonable interpretation standard in post-grant reviews, this bill is a delicate compromise between competing interests. I hope we can deal with the 9C problem in the future, but overall, this is a great bill. I'm not going to let the perfect get in the way of the doable. I hope my colleagues who have minor objections to the bill don't do the same. We've got to stop this abusive patent trolling litigation, and this bill will do it, and I urge my colleagues to support it. I yield back.
The gentleman's time has
Madam
expired.
Speaker.
The gentleman from Michigan is recognized.
I'm pleased now to yield to a senior member of the Judiciary Committee, Jerry Nadler of New York, 2 minutes.
The gentleman from New York is recognized for 2 minutes.
I thank the gentleman for yielding, Madam Chairperson. I rise in reluctant support of this bill, of the Innovation Act. The bill addresses the issue of patent trolls suing large companies, small businesses and retailers over vague patents and using the cost of litigation as a weapon of extortion to secure settlement fees. The bill is real, the problem is real, and addressing it is important. The bill proposes to address the problem by providing end-user defendants the ability to switch the suit to the manufacturer when confronted with patent trolls, increases transparency of patents and the companies that own them, and asks the Judicial Conference to review and amend certain discovery rules. These are reasonable changes to the current law that will help reduce the burden of patent trolls on our economy. Unfortunately, the bill does not deal with the problem of diversion of user fees from the Patent Office. Unfortunately, also, the authors of the bill have grafted the Republican agenda of so-called tort reform onto the bill. These provisions may severely limit the ability of real inventors and those with meritorious patent claims to obtain justice in our courts. They are deeply troubling and ought to be addressed by amendments to the bill now and improvements to the bill when it is taken up by the Senate. The most troubling provision is the loser pays provision. I oppose loser pays provisions in general and in this context as well. The reason is one of fairness. I don't believe that only large corporations or the wealthiest members of society should have access to justice. Already the threat of the enormous cost of litigation may act to prevent individuals from pursuing even the most meritorious civil liability claims. For most individuals and small businesses, the financial risk of having to pay the other side's costs and legal fees as well is one too great to bear, no matter how valid the claim. It is simply not fair to unnecessarily punish individuals with serious and meritorious claims for seeking justice. Keep in mind, a person or a business can have a legally legitimate dispute regarding fact and law and yet still ultimately lose the case. They shouldn't be unduly punished for trying to protect their interests in court. Furthermore, we don't want to create a situation where experienced corporate defendants with enormous resources and expert legal talent can bully injured plaintiffs into unfair settlements due to the risks associated with losing a potentially successful case.
I yield the gentleman an additional half-minute.
Thank you. I have other concerns as well when it comes to some of the bill's modifications of pleading standards. But we must deal with the real problem of patent trolls exploiting the current legal system for illegitimate purposes. We must disrupt the business model of the patent troll. We must prevent the extortion of small businesses across America. I will support the bill today, but I want to encourage our friends in the Senate to do a better job in balancing the competing interests. And I urge them in particular to insist on their version of the bill and not allow the House's loser pays provision into the final bill that we vote on in the conference report. Thank you. I yield back the balance of my time.
Gentleman's time has expired. The gentleman from Virginia is recognized.
Madam Chairman, at this time it is my pleasure to yield 2 minutes to the gentlewoman from Washington State, Ms. Delbaney, a distinguished member of the Judiciary Committee.
The gentlewoman from Washington State is recognized for 2 minutes.
Thank you, Mr. Chair. From the Judiciary Committee's examination of abusive patent litigation this year, it's clear that there's a need for legislative action. And this issue has harmed companies large and small, from big tech companies to small retailers, restaurants, and credit unions. And in recent years, even our public transit agencies have been targeted by these so-called patent trolls. In my home state of Washington, King County Metro was hit with a lawsuit in 2011 from Arrival Star, a company that claimed infringement of a patent that was so broad that it could potentially cover any system that tracks a vehicle. With this lawsuit, King County's innovative bus tracking technology and a popular mobile application called One Bus Away, which relies on Metro's data, was threatened. And even if there was a strong case to be made for challenging the patent's validity, fighting a suit like this can run into the millions of dollars and at taxpayer expense. So King County had to settle with Arrival Star, costing taxpayers $80,000. And King County was not alone. At least 11 transit systems settled with Arrival Star in response to lawsuits over bus tracking systems, rather than undertake expensive and time-consuming litigation. And this kind of litigation abuse does a disservice to the U.S. patent system and our innovation economy. And in the case of Arrival Star, harmed taxpayers in King County and many other agencies across the country. Because of the widespread impact of abusive litigation like this, there is broad support across industry and among public interest groups for measures that reduce the financial incentive for bad actors to bring predatory patent suits. Measures such as curbing the excessive cost of litigation and discovery abuse, making patent cases more efficient, and requiring plaintiffs to be precise in their claims of infringement. The Innovation Act would do all of these things, and it does so by targeting abusive behaviors rather than singling out any particular type of patent holder or business model. I'm pleased to support this bill today, but I also believe we must continue to make improvements to the bill as it moves forward in the legislative process, and I'll be supporting several amendments on the floor today and continue to work with my colleagues in both chambers to get legislation passed that strikes the right balance in protecting and strengthening our patent system. Thank you. I yield back.
The gentlewoman's time has expired. The gentleman from Michigan is recognized.
I'm pleased to recognize the gentleman from Vermont, Mr. Welch, for 1 1/2 minutes.
The gentleman from Vermont is recognized for 1 1/2 minutes.
Thank you, Mr. Chair. Patent trolls are not about protecting patents. They're about trolling for easy money at the expense of hard-working people. Patent trolling is a total and complete abuse of the patent system and a total rip-off of hard-working people. And worst of all, it's a complete abuse of good people trying to do good things in their communities. Let me give you a couple of examples. In Vermont, My Web Grocer is a web-based company, innovative, located in Winooski, Vermont. Over 180 employees. They've experienced 6 patent troll attacks. One of the trolls claimed to have a patent, and get this, on surfing the web with a mobile device. This was a stick-up. Another completely outrageous example is a Vermont nonprofit. It assists individuals with developmental disabilities. This nonprofit was targeted by a patent troll demanding payment for a supposed infringement on scanning technology. Can you imagine what it's like for a small nonprofit doing good work to get a letter that is essentially a stick-up? That's what it is. And what these businesses and nonprofits then have to decide is, do they pay the bounty or do they fight? This legislation is definitely needed so that our nonprofits, our small businesses can get on with the good work they're doing without the threat of abusive patent trolling. I yield back.
The gentleman's time has expired. The gentleman from Virginia is recognized.
Madam Chairman, at this time it is my pleasure to yield 1 minute to the gentleman from Pennsylvania, Mr. Marino, the Vice Chairman of the Courts, the Internet, and Intellectual Property Subcommittee.
Thank you, Chairman. Madam Speaker, I would like to rise in support of H.R. 3309, the Innovation Act. Each day, all across the United States, small businesses and entrepreneurs are receiving abusive letters insisting the recipient has somehow violated a patent. He or she is left with the option of complying with the letter's demands, such as by sending a check for $50,000, and all will be forgotten, or taking it to court, which could cost millions of dollars and put these businesses out of business. In 2011, patent troll cost the American economy $29 billion. I want to skip the notes and go right to common sense legislation. This is what it is. A veteran from Afghanistan came in to see me. He saved his money that he earned while protecting his country. He's got a little app that has communications with his printer. And a troll is suing him, saying he violated the patent. Well, my computer at home talks to my printer, and my kids' computer at home talks to my printer, so we must be violating some patent of some sort. This is abusive legislation. It's putting our small business entrepreneurs out of business. I urge my colleagues to support this.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Madam Speaker, I reserve at this point.
The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Chairman, may I ask how much time is remaining on each side?
The gentleman from Virginia has 20 minutes remaining, and the gentleman from Michigan has 18 minutes remaining.
At this time, Madam Chairman, it is my pleasure to yield 2 minutes to the gentleman from California, Mr. Issa, a distinguished member of the Judiciary Committee. I do not see him in the room, so we will come back to him in a moment. And at this time, we'll yield 1 minute to the gentleman from California, Mr. Cardenas.
The gentleman from California is recognized for 1 minute.
Thank you, Madam Speaker, members.
I rise today in support of the Bipartisan Innovation Act, which makes important reforms to the U.S. patent system to curb abusive litigation. I've heard from businesses of all sizes and in all industries in my district about the added burden faced by too many companies at the hands of patent assertion entities or patent trolls. Resources should be better spent on business expansion, job creation, development of new tools or services, or improved infrastructure instead of being used to pay settlements or even unnecessary licenses. Enactment of the Innovation Act would go a long way towards solving this problem. We must support American innovation, job creation, and economic growth. I urge my colleagues to vote yes on H.R. 3309, the Innovation Act. As a former small business owner myself, one of the things that can hinder job growth in any small business or any community is unnecessary and frivolous lawsuits. Thank you, and I yield back the balance of my time.
The gentleman yields back. The gentleman from Michigan is recognized.
Madam Speaker, I reserve my time at this point.
The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Chairman, at this time, it is my pleasure to yield 1 minute to the gentleman from New York, Mr. Jeffries, a distinguished member of the Judiciary Committee.
The gentleman from New York is recognized for 1 minute.
Thank the Chairman for his stewardship and the ranking member for his legitimate expressions of concern. This bill is a work in progress, but it's a meaningful step in the right direction as it relates to dealing with a patent troll problem that is adversely impacting small businesses, startup companies, tech entrepreneurs, innovators, and inventors in New York City and all across the country. In our judicial system, we must ensure that outcome is determined on the basis of the merits of a claim and not the high cost of litigation in the patent context. When the latter occurs, innovation is hurt. We must also jealously guard the ability of legitimate patent holders to vindicate their rights in court. And with respect to that concern, there is still significant work to be done in the Senate, particularly as it relates to Section 285, but notwithstanding that concern, this bill, the Innovation Act, represents a solid foundation upon which to address the patent troll dynamic, which almost everyone in this chamber agrees is a significant problem, and for that reason, I urge my colleagues to vote yes.
The gentleman's time has expired. For what purposes the gentleman from, the gentleman from Michigan is recognized.
Madam Speaker, I'm pleased now to yield to the distinguished gentleman from California, Mr. Rohrbacher, 2 minutes.
Gentleman from
3 minutes.
The gentleman from California is recognized for 3 minutes.
Thank you.
Well, we've certainly heard a lot about trolls, haven't we? Maybe we should understand exactly how that word came about to be used in this debate. A top executive from one of the huge electronics mega companies, these international corporations, were sitting around one day, and one of them happened to tell me about the conversation they had, which is, how do we demonize the small inventor who is coming at us because we are infringing on his patents? How do we do that? We can't attack the small inventor because people know that's where the progress of the United States comes from, is our independent inventors. We can villainize the lawyers who represent those small inventors. And they went around the room, and this executive tells me about this conversation, well, what should we call them? What's a sinister, evil sound that can get away from the fact that we don't have our own arguments, and our arguments against this don't stand up, that we're really attacking the little guy's ability to prevent us from stealing his patent? What words can we use that can get people so they won't see that? Let's call them trolls. Now, the guy who was talking to me, who was in the conversation, he was an executive from one of these in multinational corporations, he told me, he says, well, I suggested patent pirates, but trolls sounded so much more sinister. That's what we're here today. And every time you hear the word troll, what you're hearing is a manipulation of this debate by some very special interest, powerful interest, who wants to steal from the independent inventor. Everything in this bill that we're talking about, trolls, actually impacts on America's independent inventors in a dramatic way. This undercuts, this is the greatest attack, the biggest attack on the independent inventor in the 25 years that I've been a member of Congress. The fact is, these big multinational corporations are infringers. Every one of the big corporations behind this bill that's trying to have us ram this through with the Congress is guilty of multiple, has been found guilty of multiple infringements against small inventors. And so they're going to get us, oh no, we're going to pass rules in the name of stopping the trolls, which are really going to undercut the small inventor in this country. This is a disaster. This is the anti-innovation bill. This is the let's kowtow to these multinational electronic corporations like Google, who has poured lots of campaign donations into this issue on Capitol Hill in the last few years. No, let's watch out for the little guy. You know, what we have, the Philo Farnsworths or the Edisons, the people who actually came up with the changes that have made America secure, made us prosperous, made our people competitive with cheap labor overseas because we've got the technology. Yeah, let's make sure that we don't smash this generation's Edisons and Philo Farnsworths. I oppose this bill.
The gentleman's time has expired. The gentleman from Virginia is recognized.
Madam Chairman, I yield myself 30 seconds to affirm what we have said from the outset. This bill is designed for the little guy, both the innovator, the inventor, and the end-user small business that is getting subject to these trolling attacks. No innovator, no inventor, no one who brings a lawsuit to perfect their claim should fear this legislation unless their claim has no reasonable basis in law or fact. It is only then that they would be disadvantaged. In fact, most of the provisions in this bill are designed to lower the cost of litigation. The big guys can pay all they need to for litigation. The little guys can't afford to. And by lowering the cost of litigation, we're going to create greater opportunity both for the innovators to pursue their good claims and for the little guys on the receiving end who get these outrageous demand letters on the other side who are having to pay outrageous costs or simply pay money. At this time, Madam Chairman, I am pleased to yield 2 minutes to the gentleman from California, Mr. Issa, a distinguished member of the Judiciary Committee. He's keeping me guessing. Well, we have a distinguished gentlewoman from California.
The gentleman from California is recognized.
Gentleman is recognized. The gentleman is yielded 2 minutes.
For 2 minutes.
Thank you, Mr. Chairman. My colleague from California a few moments ago spoke eloquently on behalf of the small inventor. But he didn't speak for me, and I'm a small inventor. When I patented my first product, all I had were a couple of employees, an idea, and I'd presented a product that I really wanted to make to a company that I thought would buy it, and then I raced down to protect my rights and succeeded and ultimately was paid. I know very well what you do if you assert patent infringement if you want to prevail. You look at the competitor's product. You take some due diligence. All this legislation is trying to do, and do well, is to put some teeth into what my colleague from California disparaged, the trolls who will simply surf the Internet and send out litigation alleging patent infringement with products they've never looked at and understood, nor do they know if they fall under their patent. I've received damages under Rule 11 sanction. I know what it takes to show a completely frivolous case. And I prosecuted my own patents against infringers, and I know what you should do before you assert to somebody patent infringement. This bill does one thing very well. It puts a little bit of teeth finally back into what the trolls use as a tool. File a lawsuit, collect an amount of money because people don't want to spend it on litigation. Just for once, I'd like us to understand this is not sponsored by the big guys. In fact, the little guy starting a company who gets a letter or a suit from a troll is the person that this will protect. I know this firsthand from more than 3 decades of being an inventor. Mr. Chairman, I thank you for your leadership on this issue, and I yield back.
The gentleman from California yields back. The gentleman from Michigan is
Madam
recognized.
Speaker, I'm pleased now to yield to the distinguished gentleman from Georgia, Mr. Johnson, 3 minutes.
The gentleman from Georgia is recognized for 3 minutes.
Thank you, Madam Speaker, Mr. Chairman.
I think it's time this morning to reveal a little bit of truth. You know, we've had reports of trolls just running through the marketplace of America. Trolls, you know those, the ones that hang out under bridges and scare you when you were a child. You know, a troll is just something that is, oh boy, it's to be avoided. And so all patent plaintiffs bringing actions to protect their patents, we're now calling them trolls. And that's not true. That's not accurate. In fact, it's very inaccurate. Only 5% of the patent cases that are filed in the courts of this country could be considered done in bad faith. So you could call those plaintiffs, I suppose, patent trolls, but 5% of the litigation does not equate to we're being overrun by patent trolls. That's just not correct. There is a problem with abusive litigation, and so how do you get at that? How do you without closing the courthouse door on plaintiffs seeking to assert their rights to their patents, and those plaintiffs tend to be small entities, mom and pop inventors back in the garage or down in the basement, some 28-year-old ex-Harvard junior who dropped out and comes up with the next thing that explodes in the technology field. You know, how do we protect those folks who are trying to honestly protect their patents? I submit that H.R. 3309 goes way beyond what is necessary, and it also has some constitutional implications. The Rules Enabling Act was passed by Congress back in 1934, and that Rules Enabling Act was a very wise and considered piece of legislation. It recognized the fact that federal courts would be better off, and the federal body of law would be better off if we leave it to the federal courts to determine their rules of procedure. And so prior to 1934, there was... I grant the gentleman an additional minute. Thank you.
The gentleman's recognized.
Prior to 1934, there was something called the conformity principle, which held that federal court procedures should be in accordance with the states wherein those federal courts sat. But that proved to be unworkable, and so the Rules Enabling Clause went into effect, and since then we've left it to the federal judiciary through the Judiciary Conference to promulgate rules of procedure in both civil and criminal cases, and it has worked well. But now we have Section 6 of this Patent Troll Act that imposes upon our judiciary rules of procedure, and these rules have not been recommended by the Judicial Conference. In fact, the Judicial Conference, led by Chief Justice Roberts, is opposed to this change, and therefore I think on constitutional grounds this should be defeated. And I yield back.
The gentleman's time has expired. The gentleman from Virginia is recognized.
Madam Chairman, at this time it's my pleasure to yield 3 minutes to the gentleman from Nebraska, Mr. Terry, for the purpose of engaging in a colloquy with the gentleman from Utah, Mr. Chaffetz, and myself.
The gentleman from Nebraska is recognized for 3 minutes.
Thank you, Madam Chair, and I rise for the purpose of entering into a colloquy from my friend from Utah joining with me. Now, Chairman Goodlatte, I want to thank you for your attention to the very serious problem of patent assertions entities, otherwise known as patent trolls, here today. On November 14th, the House Energy and Commerce Committee held a hearing entitled, quote, "The Impact of Patent Assertion Entities on Innovation and the Economy." We heard from a variety of witnesses and industry, including the food, hospitality, tech, all of whom had been targeted by vague, unfair, and deceptive patent troll demand letters. That hearing revealed significant economic harm to Main Street businesses and the economy caused by such patent troll demand letters. These entities engage in abusive practices that often target small businesses because they don't have the resources to fight back. At the markup for the Innovation Act, Mr. Chaffetz offered an amendment that resulted in a sense of Congress in the bill before us today. That language says, and I quote, "It's an abuse of the patent system and against public policy for a party to send out a purposely evasive demand letters to end users alleging patent infringement," end quote. As chairman of the House Energy and Commerce Committee, Subcommittee on Commerce, Manufacturing, Trade with jurisdiction over these type of consumer abuses, I join with your sentiments. We understand that time is of the essence. I want to yield to Mr. Chaffetz at this point.
I thank the Chairman, Chairman Terry, for his good leadership and work on this, and certainly Chairman Goodlatte for bringing this bill, and knowing that you, Mr. Terry, are working on a bill that I'm going to wholeheartedly support. We received support for this approach from many business groups, including the National Retail Federation, National